Hello everyone, welcome back to the channel EduTap. I am Arshdeep Kaur and today we start with a different topic, that is CRPC. Now we will be dealing with all the important questions that form a part of your syllabus from CRPC, right? So we start with the Code of Criminal Procedure 1973. There are going to be 2 lectures on this topic. So I have been stressing on this point that security laws, they form a very important part of your syllabus. So do not leave any part of that. But at the same time, you have to remember that criminal law, it also has been given 30% weightage. It also is important, so make sure that you cover these topics as well, that is your IPC, the CRPC and the Indian Evidence Act. And as of today, we start with the CRPC 1973. Alright, before I start, I would like to tell you that EduTap has come up with 2 courses for the phase 2 examination. The first is the test series and other one being the live crash course. For the test series, you get chapter wise test. That means for each and every chapter that is mentioned in your act, you get a different test for that, for which you can practice. So like in IPC, there are different chapters. In CRPC, there are different types of chapters. So you get separate test for each such chapter. Then you get full length test with evaluation. So this time, because of the descriptive part, you need evaluation. So that is why our experts are going to evaluate your test. So you will get required feedback from our experts so that it can help you for your preparation. So you get full length test with evaluation. And you also get one-on-one mentor support. And for the live crash course, the live classes, they have already been started. It is going to be very helpful for your preparation. You also get short notes for that, so it will be very helpful in your descriptive part. All the features of the test series that I have just mentioned, they all are included in the live crash course, and again you get one-on-one mentor support. So this is going to be very helpful for your preparation and your revision as well. So please make sure that you avail our offer, which is going on right now. So if you want to avail it, kindly refer to the link in the description below. Now let's start. Question number 1. The term taking cognizance under the provision of the Code of Criminal Procedure 1973 means starting a trial, completing pre-requirements for starting a criminal trial, taking notice of the matter judiciously, and administrative action to decide if the criminal trial is required. The answer is C, that is taking notice of the matter judiciously. Right? So what is taking cognizance has not been defined in the code. Literally, it means to become aware of, but when used with reference to a court or a magistrate, it means to take judicial notice of an offence. So here you take judicial notice of the offence. We are not talking about deciding the case, or we are not talking about going into the facts of the case. We are just talking about taking judicial notice of the case, right? So this is taking cognizance. Question number 2. Besides the high courts and the courts constituted under any law other than this code, which of the following is not a criminal court? Court of Session, District Magistrate, Judicial Magistrates of the first class and in any metropolitan area, Metropolitan Magistrates, Judicial Magistrates of the second classes, or Executive Magistrates. So the answer is B, that is District Magistrate, right? So besides the High Court and the courts constituted under any law other than this code, there shall be in every state the following classes of criminal courts, namely, the first is the Court of Session, then Judicial Magistrate of the first class, and in any metropolitan area it will be called a Metropolitan Magistrate, Judicial Magistrates of the second class, and Executive Magistrates, right? Question number 3. Which provision of CRPC states that warrant issued by a magistrate of India may be executed at any place in India? So the answer to this question is option C, that is section 77 of CRPC. A warrant of arrest may be executed at any place in India. Question number 4. No court shall take cognizance of an offence of the category specified in subsection 2 of section 468 after the expiry of the period of limitation. Which of the following is correct with respect of the period of limitation? So the answer to this question is actually A, that is 3 years if the offence is punishable with imprisonment for a term exceeding 1 year but not exceeding 3 years, right? So this is section 468. Except as otherwise provided elsewhere in the code, no court shall take cognizance of an offence of the category specified in subsection 2 after the expiry of the period of limitation. And what is going to be the period of limitation? The period of limitation shall be 6 months if the offence is punishable with fine only. So if the offence is only punishable with fine, in that case it is going to be 6 months. 1 year if the offence is punishable with imprisonment for a term not exceeding exceeding 1 year, and 3 years if the offence is punishable with imprisonment for a term exceeding 1 year but not exceeding 3 years. For the purpose of this section, the period of limitation in relation to the offences which may be tried together shall be determined with reference to the offence which is punishable with more severe punishment, or as the case may be with the most severe punishment. So what are they saying? For example, let's just say that there are 2-3 offences that are being tried together. So what is going to be the period of limitation in that case? So the period of limitation will be counted according to the offence that has the most severe punishment of them all, right? So this is what this is clause 3 is talking about. So I hope you are clear with this section also. Moving on, question number 4. A judgment includes an order of discharge, should not contain the name of the victim in case of sexual offences, must be written in the language understood by the accused. In case of acquittal, need not direct the accused to be set free. Answer is option B, that is should not contain the name of the victim in case of sexual offences, right? So name and identity of the victims of rape and sexual assault, including those who have died, cannot be disclosed even in a remote manner. A judgment cannot mention the name of the victim for the offences under the Indian Penal Code or POSCO, that is Protection of Children from Sexual Offences. Question number 5. If the accused is convicted in a criminal case for an offence under the statute which does not provide for the payment of compensation, then, so the right answer is C. The court can award compensation under section 357 of the CRPC, but the award will be taken into account in the subsequent civil suits. Compensation belongs to the domain of civil law, but with the new trends in victimology, compensation must be paid to the victim. Let's read this section about compensation. This is section 357, order to pay compensation. When a court imposes a sentence of fine or sentence including a sentence of death, or which fine forms a part, the court may, when passing judgment, order the whole or any part of the fine recovered to be applied. So when the fine already is a part of the sentence, right, it already forms a part of the sentence, in that case the whole of that fine or the part thereof, it can be used by the court for the following matters, right? In defraying the expenses of properly incurred in the prosecution. So for example, the cost that the prosecution has incurred, in the payment to any person of compensation for any loss or injury caused by the offence, when compensation is, in the opinion of the court, recoverable by such person in a civil court. So in case that the court thinks that such compensation is recoverable in the civil law, then also the fine can be awarded as a compensation, right? When any person is convicted of any offence for having caused the death of another person or having abetted the commission of such an offence, in paying compensation to the persons who are under the Fatal Accident Act 1855 entitled to recover damages from the person sentenced to the loss resulting to them from such death. When any person is convicted of any offence which includes theft, criminal misappropriation, criminal breach of trust, cheating, or having dishonestly received or retained, or having voluntarily assisted in disposing of stolen property, knowing or having reason to believe the same to be stolen, in compensating any bona fide purchaser of such property for the loss of the same if such property is restored to the possession of the person entitled thereto. So for example, there was a stolen property, and that stolen property, it was purchased by a person who did not know that it was a stolen property. He was a bona fide purchaser. In that case, his interest has to be protected, right? So now that the stolen property, it goes to the rightful owner, but the bona fide purchaser who actually paid for that stolen property, he is going to be compensated from this fine, right? So that is why they have included all these offences, that is theft, criminal misappropriation, criminal breach of trust, cheating, or having dishonestly received or retained, or having voluntarily assisted in disposing of the stolen property, knowing or having a reason to believe the same to be stolen. So in these cases, you have to do what? You have to compensate the bona fide purchaser. Alright, next. If the fine is imposed in a case which is subject to appeal, no such payment shall be made before the period allowed for presenting the appeal has elapsed, or if an appeal be presented before the decision of the appeal. So in case there is an appeal that lies, in that case you cannot ask for this compensation, you will not get this compensation till either the appeal it has not been filed and the period of limitation has expired, or the other thing is that it has been filed and it has been disposed of, right? When a court imposes a sentence of which fine does not form a part, the court may, when passing judgment, order the accused person to pay by the way of compensation such amount as may be specified in the order to the person who has suffered any loss or injury by the reason of the act for which the accused person has been so sentenced. So in case that no fine is imposed, in that case the court can do what? The court can actually pass an order for the compensation. They are only talking about the cases where fine does not form a part of the punishment itself, right? An order under this section may also be made by the appellate or the High Court or the Court of Session when exercising its power of revision. So a revision court, an appellate court and a High Court or a Court of Session, they can also order to pay compensation. At the time of awarding the compensation in any subsequent civil suit relating to the same matter, the court shall take into account any sum paid or recovered as compensation under this section. So in case there is also another civil suit that is going on and any compensation is awarded in that suit, in that case the compensation that is awarded under this section, it will be taken into account while ordering the compensation there, right? So at the time of awarding compensation in any subsequent civil suit relating to the matter, relating to the same matter, the court shall take into account any sum paid or recovered as compensation under this section. So I hope you are clear with this section. Moving on, question number 6. According to CRPC, the period of limitation in relation to an offence shall commence. So the answer to this question is D, that is A, B or C. Let's read the section itself. The period of limitation in relation to an offender shall commence on the date of the offence. Second, where the commission of the offence was not known to the person aggrieved by the offence or to any police officer the first day on which such offence comes to the knowledge of such person or to the police officer, whichever is earlier. And third, where it is not known by whom the offence was committed the first day on which the identity of the offender is known to the person aggrieved by the offence or to the police officer making investigation into the offence, whichever is earlier. In computing the said period, the day from which such period is computed shall be excluded, right? Moving on, question number 7. Which provision of the Code of Criminal Procedure 1973 deals with the power of the magistrate to arrest? So the answer is actually section 44, that is option B. Arrest by the magistrate. So here what is happening is that the magistrate is himself arresting a person, right? And there are two different situations. The one is he sees the offence himself, he sees that person is committing that offence himself, and the second one is he either gets information from any other person, right? So when any offence is committed in the presence of the magistrate, so he has seen that offence being committed in his presence. So when any offence is committed in the presence of the magistrate, whether executive or judicial, within his local jurisdiction, he may himself arrest or order any person to arrest the offender and may thereupon, subject to the provisions herein contained as to bail, commit the offender to custody. So he can straight away do what? He can straight away send that person to the custody because he is himself a magistrate and he has seen that person committing that offence himself. He does not have to order that person to be produced in front of another magistrate. He can straight away do what? He can straight away, subject to the bail, if there is bail possible, then in that case bail is going to be granted, but subject to the conditions of the bail, he can do what? He can commit that person to custody, right? The second one is any magistrate, whether executive or judicial, may at any time arrest or direct the arrest in his presence within his local jurisdiction of any person for whose arrest he is competent at the time and in the circumstances to issue a warrant. Here the magistrate has not seen the offence being committed in his presence, so he can do what? He can arrest that person, but again that person, he has to be produced in front of another magistrate, right? So any magistrate, whether executive or judicial, it is for both executive and judicial magistrates, may at any time arrest or direct the arrest in his presence within his local jurisdiction of any person for whose arrest, he is competent at the time and in the circumstances to issue a warrant. Question number 7. Which of the following deals with the cases in which bail is to be taken? So the answer is option C, that is section 436 CRPC. In what cases bail is to be taken? They are talking about the bailable offences, right? When any person other than a person accused of a non-bailable offence, that is bailable offence, is arrested or detained, either he is arrested or he is detained without warrant by an officer in charge of a police station, or appears means that he voluntarily appears, or is brought before a court and is prepared at any time while in the custody of such officer or at any stage of the proceeding before such court to give bail, such person shall be released on bail. Any such person who is ready to meet with his conditions of bail, in case he will be granted bail, right? But there's a proviso provided that such officer or the court, if he or it thinks fit, may and shall, if such person is indigent and is unable to furnish surety, instead of taking bail from such person, discharge him on his executing a bond without sureties for his appearance as herein provided. In case he is an indigent person, he is a poor person, in that case no surety will be taken from him and he will be released on executing the bond itself, right? Where a person is unable to give bail within a week of the date of his arrest, it shall be sufficient ground for the officer of the court to presume that he is an indigent person for the purpose of this proviso. So in case that a week has elapsed and he has not paid his surety, he has not paid for his bail, in that case it will be assumed that he is what? He is an indigent person. Notwithstanding anything contained in subsection 1, where a person has failed to comply with the conditions of the bail bond as regards to the time and place of the appearance, the court may refuse to release him on bail when on a subsequent occasion he appears before the court or is brought in custody, and any such refusal shall be without prejudice to the powers of the court to call upon any person bound by such bond to pay the penalty thereof under section 446. So this is the only ground that has been mentioned here, that is the non-appearance. Non-appearance is the only ground that is mentioned here of cancelling the bail, right? So if a person, he does not come, he does not appear when he is required to, in that case his bail, his bail can be cancelled, right? And the Supreme Court has time and again stressed on this part that the bail, the condition to the bail, it should not be such that it leads to rejection of bail, right? So I hope you are clear with this section also. Moving on, question number 9. The term victim is defined under, this is an important section, so it is defined under, that is section 2WA, that is option B is correct. Who is a victim? Victim means a person who has suffered any loss or injury caused by the reason of the act or omission for which the accused person has been charged, and the expression victim includes his or her guardian or legal heirs, right? So this is an important question, it can be asked, so please make sure that you know this question. Question number 10. Who among the following is not entitled to claim maintenance under section 125 of CRPC? So the answer to this question is B, that is unmarried sister, right? So these provisions of maintenance, they actually belong to the domain of civil law only. But why they are included here? Because we need a speedy result, right? They are talking about maintenance. हो सकता है that person who is demanding that maintenance, who is claiming that maintenance, does not even have sufficient means to survive. So that is why to get this maintenance readily, that is in a speedy manner, that is why they have added this in CRPC also. But you have to remember that just because you are filing an application for maintenance under this section, it does not preclude you, it does not bar you from initiating the same suit for maintenance under any law that provides for maintenance, right? So that means you can go under the secular law being the CRPC, and at the same time you can go for your personal law also, for example Hindu law, right? So you can go under that law also. So let's read what are the provisions of section 125 under CRPC. If any person having sufficient means neglects or refuses to maintain. So you have to remember that sufficient means, he is having sufficient means what? According to the Supreme Court, it means that he has earnings every month. If any person having sufficient means, if he has sufficient means and he neglects or refuses, that means he is intentionally doing it, right? To maintain, his wife unable to maintain herself, his legitimate or illegitimate minor child, whether married or not, unable to maintain itself, his legitimate or illegitimate child not being a married daughter who has attained majority, where such child is by the reason of any physical or mental abnormality or injury unable to maintain itself, or his father or mother unable to maintain himself or herself, a magistrate of the first class may, upon proof of such neglect or refusal, order such person to make a monthly allowance for the maintenance of his wife or such child, father or mother at such monthly rate as such magistrate thinks fit, and to pay the same to such person as the magistrate may from time to time direct. Provided that the magistrate may order the father of a minor female child referred to in clause B to make such allowance until she attains her majority, if the magistrate is satisfied that the husband of such minor female child, if married, is not possessed of sufficient means. Provided further that the magistrate may, during the pendency of the proceedings regarding monthly allowance for the maintenance under this subsection, order such person to make monthly allowance for the interim maintenance of his wife or such child, father, mother, and the expenses of such proceedings. So here the provision of interim maintenance has also been included. So in case while the proceedings they are going on, in that case also interim maintenance and the cost for the proceeding they can be paid. The court can make them to be paid to that person, right? So that is what this is known as interim maintenance. Which the magistrate considers reasonable, and to pay the same to such person as the magistrate may from time to time direct. Provided also that an application for the monthly allowance for the interim maintenance and expenses for proceedings under the second proviso shall, as far as possible, be disposed of within 60 days from the date of the service of the notice of the application to such person. I told you that this is for the speedy result, that is why it has been given that it has to be made within 60 days, right? Explanation: minor means a person who under the provisions of the Indian Majority Act is deemed not to have attained majority, that is 18 years. Wife includes a wife who has been divorced by or has obtained a divorce from her husband and has not remarried. So if a wife has divorced, in that case also she is entitled to maintenance unless and until she remarries. Such allowance shall be payable from the date of the order, or if so ordered, from the date of the application for the maintenance, right? So I hope you are clear with question number 10 also. Moving on, question number 11. A High Court, under its inherent powers conferred under section 482 of CRPC, passes the following order. It quashes the FIR. It quashes proceedings of the case pending before a criminal court. It expunges the derogatory remark against a member of the subordinate court. Which of the following is correct? So the answer to this question is C, that is 1, 2 and 3 all are valid. So they are talking about the inherent powers of the High Court. In CPC, every court was given inherent powers, but in CRPC only the High Court has been given inherent powers, right? But you have to remember that you cannot go under the inherent powers of the High Court and ask for anything that is already provided in the CRPC. So if a remedy is already provided in the provisions of CRPC, then you cannot ask the High Court to invoke its inherent powers and provide you with the remedy, right? So nothing in this court shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary to give effect to any order under this code, or to prevent abuse of the process of any court, or otherwise to secure the end of justice, right? So these are the reasons when the inherent powers they can be invoked. For example, while we were dealing with the question of bail, in that case we have just read one reason. The reason was that non-appearance can only lead to cancellation of bail in bailable offences. But what if that person who has been granted bail, he is fabricating the evidence or tampering with the evidence? In that case, will his bail be not cancelled? The answer is yes, it will be. Under what? Under this section, invoking the inherent powers of the High Court. There only one option is available, only one option has been given. In any other case which is not mentioned in CRPC, in that case we can do what? We can invoke the inherent powers of the High Court and we can ask the High Court to do the same for us, right? So this is section 482. These examples: it quashes the FIR, quashes proceedings of the case pending before the criminal court, expunges the derogatory remark against the members of the subordinate court. These are also the examples which are correct, right? Question number 12. Section 311 of the Code of Criminal Procedure 1973 applies. Answer is D, all of the above, at any stage of trial, at any stage of inquiry, at any stage of proceeding, right? So this is power to summon material witness or examine person present. Any court may, at any stage of the inquiry, trial or other proceeding under this code, summon any person as a witness or examine any person in attendance not summoned as a witness, or recall and re-examine any person already examined, and the court shall summon and examine or recall and re-examine any such person if his evidence appears to it to be essential to the just decision of the case. So this section, this is only invoked in interest of justice, right? This is a discretionary power of court. This is a truly discretionary power. If the court thinks fit, if it is satisfied, then in that case it is going to do what? It can examine, re-examine the witnesses that has already been examined, right? And it can be for both, that is for the prosecution also and for the defense also. So I hope you are clear with question number 12 also. Moving on, question number 13. Which of the following requirements need not be followed under section 200 of the Code of Criminal Procedure 1973? The complainant must be examined. Examination of the complainant must be under oath. The accused must be given an opportunity to be heard. The examination of the complainant must be reduced to writing. So the answer is C. That is only 3. The accused must be given an opportunity to be heard. That is not right under section 200. The opportunity of being heard, the accused actually comes under section 204 in case of complaint cases. Let's understand the procedure of complaint cases very quickly. First of all, the magistrate, he takes cognizance under section 190, right? He takes cognizance under 190, and then under section 200, he examines the complainant. In that case, if he thinks that there is sufficient grounds to move on, there are sufficient grounds to proceed, in that case, he can do what? He can either ask for detailed inquiry under section 202. If he thinks that no such case is made out, then he can dismiss it under 203. And in case he thinks that sufficient grounds they are present to proceed with this case, in that case he calls the accused under section 204. So here in this section we are talking about the complaint cases, right? So let's read this section first. Magistrate, taking cognizance of an offence on complaint, shall examine upon oath the complainant and the witnesses present. So what is happening here? There is a complainant who has come to the magistrate and he is making a complaint, right? He is stating a complaint. In that case, what is going to happen? In that case, the magistrate is going to take under oath his statement and any witnesses that is present that he has brought with him, if any, and the substance of such examination shall be reduced to writing and shall be signed by the complainant and the witnesses and also by the magistrate, and they are also going to do what? They are going to sign it. Provided that when the complaint is made in writing, the magistrate need not examine the complainant and the witnesses if a public servant acting or purporting to act in the discharge of his official duty or the court has made the complaint. In that case, the court need not to examine that complainant, and if the magistrate makes over the case for inquiry or trial to another magistrate under section 192, and in that case also the court need not to examine that complainant. Provided further that if the magistrate makes over the case to another magistrate under section 192 after examining the complainant and the witnesses, the later magistrate need not to re-examine them. But for example, that you were not supposed to examine that complainant but you did. In that case, the other magistrate now who gets that case, he is not going to re-examine that complainant. So here we are talking about the complaint cases, that is the non-cognizable cases. But what are non-cognizable offences? The offences in which the police officer, he cannot arrest without warrant. He cannot start investigation because they are what? They are complaint cases. And on the other hand, the cognizable offences are what? Cognizable offences are the offences. They are the serious offences which the police officer, he can arrest without warrant and he can start the investigation in that matter with or without the permission of the court, right? Please remember that while we are talking about the cognizable offences, we talk about the police officer and we say the word investigation. The term investigation is related to the police officer, and when we are talking about the magistrate under the complaint cases, we are talking about the inquiry. The magistrate does what? The magistrate does the inquiry and the police officer does the investigation, right? Under this section, this is just a pre-trial process. You don't have to go under the details of the offence. You just have to make out that if there are grounds to proceed, that a case is made out against the accused. This is all you have to see. You don't have to see that sufficient grounds for his conviction are present. Only have to see that sufficient grounds are present to move against the accused, right? And under this section, the accused has no right to be heard, right? Okay, there's one more thing that I have told you, that in cases of the non-cognizable offences, the complaint cases, the magistrate can take cognizance and start with the inquiry, right? But for example, let's just say that the FIR is not being registered, and the person, the victim, he actually moves to the magistrate and he asks the magistrate to register his complaint. In that case also, this complaint, it can be registered. So it is no bar that it has to be a non-cognizable offences only, right? So under a cognizable offence also, the magistrate can take cognizance and examine the complainant, right? Alright, moving on, question number 14. The term cognizable offences is defined in, so the answer is option B, that is section 2C. Defines it to be an offence in which the police officer can arrest the convict without the warrant and can start investigation without the due permission of the court. These are the offences that are usually very serious and generally heinous in nature. For example, rape, murder, kidnapping, dowry death, etc. So I have told you, in a cognizable offence, the police officer, he has been given this power that he can arrest without warrant and he can start his investigation without any permission of the court. Alright, last question, question number 15. Under section 372 of CRPC, a victim, answer is A, that is 1 and 5, can file an appeal against the order of the acquittal, can file an appeal against any order convicting for a lesser offence or imposing inadequate compensation. No appeal to lie unless otherwise provided. So, no appeal shall lie from any judgment or order of the criminal court except as provided by this court by any other law for the time being in force. So this we have already done in CPC also, that your right to appeal, this is your statutory right. So it is given from statute, right? So that is why it is a statutory right. And under CPC you have 2 appeals, and in CRPC you only get what? You only get 1 appeal. Provided that the victim shall have a right to prefer an appeal against any order passed by the court acquitting the accused or convicting for the lesser offence or imposing inadequate compensation, and such appeal shall lie to the court to which an appeal ordinarily lies against the order for conviction of such court. So this proviso, this was actually added in 2008 because of the victimology, because of the new trends in victimology, right? It was added in 2008, which now gives the victim a right to file an appeal in case of acquittal also, right? The grounds of such appeal are acquitting the accused, convicting for a lesser offence or imposing inadequate compensation. But for inadequate sentence, it is not mentioned here. In case the accused, he has been given inadequate sentence, then in that case the victim can do what? The victim can file a revision, because this is not mentioned in this section, right? So I hope you are clear with these 15 questions. They are really important for you. Now the question for achievers. Which of the following is true about the confession under the provisions of the Code of Criminal Procedure 1973 can only be made to the authorized person? Only the magistrate enjoys the power of recording confessions made by the accused while in police custody to the police officer is valid under the provisions of Code of Criminal Procedure 1973. Made to the police officer in presence of the magistrate are valid. So you have to comment the right answer below. So that was all for today. I hope it was a helpful session for you. For more such videos, please like, share and subscribe to the channel EduTap. Thank you.